What matters is not the name given to it, but the essence of the contract. What matters in contract is purpose and meaning, and not merely what and form. The borrower claims to have paid a debt without a proof, and the lender says he has not paid it. Then the debt remains due on the debtor. One important principle to consider is al-aslu baratu dhimma, which means the basis is freedom from liability. Then the borrower's liability is not assumed because there is no evidence. Assalamu alaikum wa rahmatullahi wa barakatuh. Hi, my name is Taufik. Welcome to my YouTube channel where we discuss everything about Islamic finance. Today we are going to be discussing some major legal maxims that guide Islamic finance. At the end of this video, you understand why they are so important and why you have to understand them before you take a deep dive into Islamic finance. So what are these maxims? The first one is al-umuru bimaqasidiha. Matters or issues are judged by the intention behind them. In Islamic finance, the contract is structured in a way that it is meant to end in the haram way. Irrespective of the name given to it, the contract becomes impermissible. Because what matters is not the name given to it, but the essence of the contract. Another example is if someone gives a donation in an attempt to evade or reduce the amount supposed to pay for zakah, this donation becomes impermissible because even though donation is halal, it becomes impermissible because of the intention of giving the donation, which is to evade paying zakah. Under this broad maxim, we have other principles like which means what matters in contract is purpose and meaning, and not merely what and form. That is to say, that judges contract by their substance, not just outward labels. For example, the difference between a leasing contract, which is ijaro, and a borrowing contract is rental fee. If Mr. Wakar borrows a car from Mr. Udu, for example, and the charge is stipulated using the car maybe for a week or for a month, even though the word used in the contract is borrow, so far the rental fee has been paid, it becomes a leasing contract and it's not treated as what a borrowing contract. In a nutshell, these legal maxims, matters are judged by their intention, and the second one, they are simply telling us that what matters in Islamic finance is the substance and not the form. Islamic finance therefore ensures that the form doesn't override the purpose, and ethical compliance is not just about the words, but about the intent and the structure. Another maxim that is very important and crucial to the concept of Islamic finance is al-yakinu la yazulu bishak. Certainty is not overruled by mere doubt. This means established claim or right or ownership that has been proven cannot be overruled by mere claims. Another example is that if a borrower claims to have paid a debt without a proof and the lender says he has not paid it, then the debt remains due on the debtor. Other related principles under these include al-aslu fil mu'amalat wal uqud al-ibaha. This gives Islamic finance the flexibility to evolve and adapt with new financial contracts like hybrid models, digital payments, fintech, and so on. Another important principle to consider is al-aslu baratu dhimma, which means the basis is freedom from liability. In Islamic finance, the person is not held responsible for a financial obligation unless there is clear proven evidence. For example, if A claims that B owes him money without a contract or proof, then the borrower's liability is not assumed because there is no evidence. Because B is innocent by default until proven guilty. Another contract to consider is al-aslu fi shuruti al-ibaha. Contractual conditions are permissible by default. This allows contracting parties to tailor their conditions to what suits them as long as it is not prohibited by the Sharia. For example, in a murabba contract, it is allowed to stipulate a deadline, while in a lease-to-own contract, it stipulates early option to buy. These contracts, that is, al-yakinu la yazulu bishak, al-aslu fil mu'amalat wal uqud al-ibaha, al-aslu fil shurut al-ibaha, al-aslu baratu dhimma. All these are telling us that Islamic finance allows flexibility, stability, and confidence. Another important maxim to consider is ad-dararu yuzal. Harm is to be prevented or reversed. In this maxim, you see how justice, compassion, social welfare remain core to all Islamic financial dealings and transactions. We can see the example of this in different instances, like granting respite to someone unable to pay debt, or structuring a murabba contract if the customer is unable to pay due to unforeseen circumstance or a disaster. Another related maxim to this is al-ittiraru la yubtilu haqqa al-ghayr. Necessity does not invalidate the right of others. This ensures that necessity never becomes an excuse for injustice, even in time of genuine financial constraints. For example, a debtor's inability to pay does not cancel his debt. Another example is if a financial institution is facing a liquidity crisis, they cannot resort to depositors' money without due process or permission. Another related principle to this is that is, necessity allows exceptions, but only to the needed degree, not beyond. This principle helps to ascertain balance, allowing flexibility in times of hardship without opening the door to abuse or excuse. If payment is delayed intentionally, charges may apply to deter abuse and only to the needed degree, not to make profit. Therefore, in Islamic finance, excessive fines are not allowed. We've come to the end of this video. If you've learned one or two things, do endeavor to subscribe. Once again, my name is Taufik. Your guide to Sharia compliant business. See you in the next episode. Thank you.